Welcome to the DMH Stallard Employment Law podcast. Today, we're going to be talking about the government's new proposals on employment law and what that might mean for you as HR professionals. My name's Abigail Mayno. I'm a partner in the employment team at DMH Stallard, and with me today to talk about some of these proposals is Greg Burgess, a partner in our team based in Gatwick, and Stephen Tenhove, a partner based in our London team. So let's dive in. Stephen, Labour is saying this is the most significant change in employment law for many years. Are they right in saying that, do you think?
Well, in fact, they're more ambitious still, Abby. They say in the government's briefing note that it's the biggest upgrade to workers' rights in a generation. I'm not quite sure it's as radical as all that. And I think the more radical elements of it will prove to be difficult to put into legislation, and no doubt we can discuss that a little later. I think the gist of the proposed reforms are rooted in the Taylor report that the Conservatives commissioned in 2017, and you'll recall the Good Work Plan prepared by Lord Taylor back in 2017. That led to the Labour Party producing what it called a New Deal for Working People, which it prepared in 2022, but which it actually published on its website in January of this year. They've then clarified that further by having a new policy statement called Plans to Make Work Pay, which was, I think, published in May of 2024. And we now have the King's Speech on the 17th of July 2024, which put forward the Employment Rights Bill and the Equality, Race and Disability Bill, which we'll talk about shortly. It's important to say that the bills have been mentioned, but I have not seen any draft bill at the moment. I suspect a draft bill will be prepared very shortly. It will then go out to consultation. And although the bills are hoped to be put into legislation within the first 100 days of the government, all new governments seem to be fixated with doing things in 100 days. I suspect it'll take a little bit longer than that. So I think in summary, my own view is there are some interesting and quite radical ideas, but it generally either tweaks or reverses Conservative legislation over the last 14 years. I think the exception to that is certain union and collective rights, which look quite interesting. But to be fair to the Conservatives, they kept most of the employment legislation that was put through by Tony Blair and Gordon Brown when they were prime ministers from 1997 to 2010. So there wasn't a great deal to radically change because the Conservatives hadn't changed what Labour had done. I think also that you don't have to be doing radical things in order to make a big change. One of the things the Conservatives did was to confirm that they would keep the national minimum wage in place, for example, and under the Conservatives, that has been increased enormously in real terms, of real benefit to low-paid people. So I think the picture is a little bit more complicated than the incoming government might suggest that it is, in the sense that the Conservatives did some good things and didn't tamper with much of Labour's legacy. And of course, to ordinary working people, the fact that their personal tax allowances are being frozen for the next 5 years is likely to be just as important as their new legal rights that Labour wish to give them. So I think on balance, it's not as radical as it might first appear. The radical elements are going to be quite hard to implement, I think. But it isn't radical for the good reason that the Conservatives didn't really change the employment law regime that was established under New Labour.
Okay, so but I think there are some headline grabbing potential changes to things around unfair dismissal, potentially reporting on race and disability. Let's have a look at some of the legislation which is included in the King's Speech. So I think one of them was the Employment Rights Bill, which you touched on, Stephen. So Greg, do you want me to start telling me a bit about that? What's in there? What the plans there?
Yeah. So let's deal with carrying on the theme of radical aspects of it. So the headline grabbing aspects, particularly around what we call day one rights. So the rights for individual employees that now kick in or will be kicking in from day one under the Employment Rights Bill. And the most significant of that is the right to protection from unfair dismissal, which Labour are saying will become a day one right. Most people on this podcast listening to it will know that the right typically for ordinary unfair dismissal kicks in after 2 years, having increased from 1 year some years ago. So they're saying it's going to be a day one right, but it seems that it will be subject to probationary periods and increased use of probationary periods. Exactly what that exemption will look like, we'll perhaps come on to talk about a little bit later. But that's the key headline grabbing radical changes of the day one right to claim unfair dismissal. Other day one rights that they are proposing is to get sick pay from day one, to make flexible working the default from day one. So these are other things which have been in the news as starting from the start of the employment relationship. What was interesting in the briefing note, the Labour's briefing note, is that they say that there is evidence that increasing protections from day one will encourage more workers to switch jobs, which I guess it might do, which may lead to higher wages and productivity growth. And in terms of wage rises, the government's briefing note says that wage increases will be 3 times faster for people that switch jobs other than people that stay in their job. So i.e. you go and get a new job, you've got a much better chance of increasing your pay by doing that rather than staying in your job. They also say that it will lead to productivity growth. Doesn't say exactly how or why. I guess it is that new starters may be more motivated, more productive in the first few weeks and months of their employment. So that's interesting. They're trying to link it to these, two things that we see a lot about at the moment, about wage growth, about productivity growth, but there's not really any evidence I've seen of that being the case.
No, and I guess if you were cynical, you could say that having day one rights might make employers less likely to take a chance on certain employees that they feel like might not be fully qualified, or might actually become a barrier to social mobility. Certain individuals getting jobs that they might aspire to but might not on paper have the qualifications for.
Yeah, that's right. I mean, it depends slightly on how robust the probationary period sort of exemption piece is, and if employers can get comfortable that they've got that to fall back on and they can rely on a probationary period to sort of sift out the good from the bad, then they may be comfortable moving forward with what they might see as a slightly risky recruit. I don't know. But it's unfortunately, as often happens with these things, and the cynics will say, well, it's the lawyers and who will benefit from this because it's inevitably going to lead to an increase in litigation against the tribunal systems already struggling. So that would be interesting to see what effect that has.
Okay, thanks. And so I think there are some other changes proposed from the Employment Rights Bill as well, Stephen, is that right?
Abby, yes. One of the interesting ones is reforming the law on hire and fire. We all remember the P&O scandal. The employees are told that they must accept contracts of a lower standard, otherwise they'll all be dismissed. And in extremis, in very difficult employment situations, employers rarely have an option, if they wish to remain solvent, than to reduce the salaries of their employees and terminate their existing contracts in the hope that their employees will accept new contracts, or that they will have a defence to a claim of unfair dismissal in those circumstances, because after all, the employees are being dismissed, and they can rely on some other substantial reason to show that they had a fair reason for dismissal. So the idea the government has is to ban that, but again, in the guidance, this is going to be subject to retaining a degree of flexibility when employers need it. And of course, it's really pretty difficult to see in advance what that degree of flexibility will be. I suspect they'll make it more difficult to show that you have some other substantial reason, perhaps they'll change the law slightly to make some other substantial reason less easy to prove. But again, this appears on the face of it to be radical. We're abolishing hire and fire, but it's likely to be couched with, for want of a better word, employer-friendly exceptions that can be used. And what those exceptions are of course the devil in the detail. And the Conservatives, of course, passed guidance on this only a few months ago, which came into force on the 19th of July, 2 days after the King's speech. And that was pretty toothless, and Labour have criticised it, but they have not suggested what they're going to put in its place. And so that's an interesting one to watch. They want to establish a single enforcement body for the regulation of gangmasters, the recruitment industry, and the national minimum wage, called the Fair Work Agency. And the Labour Party has much castigated the Conservatives for their toothless regulation through several different agencies and their failure to amalgamate them into one. But of course, the regulation for most of the separate regulation for recruitment for the national minimum wage was in fact set up by the previous Labour government. So what they're actually doing here is changing what Labour previously did rather than what the Conservatives did. So I think that's slightly ironic. The trade union legislation is, I think, quite interesting. What the government seeks to do is to allow unions to have access to workplaces where they're not currently represented, to see if they can recruit union members. That may be quite significant. They are also going to seek to abolish the Conservatives' 2016 legislation and 2023 legislation covering unions. The 2016 legislation made it much more difficult to obtain recognition and very tricky to hold a strike. Those are going to be watered down. So it's going to be easier for unions to obtain recognition. It's going to be easier for unions to strike. And the 2023 legislation committed the unions to preserving essential services. Labour are going to reverse that. So there are no essential services. So anyone, anywhere can have a strike, provided that the strike is in accordance with union legislation. That is not surprising. I think that the union's ability to drum up new members in new workplaces will affect employees who have previously had very little to do with trade unions. It'll be interesting to see what happens there. The rationale for this is that on the continent, unions have a constitutional right in most countries to seek members wherever they have them, and that we don't, and therefore the TUC says the union membership here is lower than it is on the continent. But broadly speaking, that doesn't seem to me to be the case. Union membership has declined across Europe for very similar socioeconomic reasons. But that will affect, I think, it may affect particularly larger clients who do not currently have unions, might find them knocking on the door, seeking to recruit their employees as union members. Another interesting thing is that under our Employment Rights Act, Section 1, Particulars of Employment, Statement of Employment, you might be obliged to tell employees in the future that they may join a union. Not just that there are no collective agreements or that there are collective agreements that apply to your employment. You may have to actually tell them they have a positive right to invite a union in to try and get them to join a union. So that's a possibility that I've heard about. So that's I think that's interesting.
Yeah.
Other things, collective rights for employees to make collective grievances. I suspect collective redundancy is going to be tightened up. Collective redundancy will go on for longer. It'll require fewer employees to be involved in the redundancy proposals of the employer, and I suspect that the payments for not the protective awards will be increased. So that's actually quite interesting stuff, and not headline grabbing, but I think it's likely to be important.
Yeah, absolutely. Something employers will need to be mindful of, and we'll talk about some of the timings of this a little bit later on. But I know, Stephen, you mentioned the Equality, Race and Disability Bill. Greg, what's that about?
So this is the second main piece of legislation that Labour are proposing to introduce. The primary aspect of it is to bring into law the principle of equal pay, not just for gender, but for ethnic minorities and for the disabled. So it was 54 years ago that the Equal Pay Act came into force, seeking to provide pay equality for men and women doing like work or work of equal value. And we've had 54 years of that legislation now. And I must say, in my 20 plus years of practicing, I have dealt with a handful of equal pay claims. They are very difficult claims to litigate, whether that's for the employee or defending them for the employer. They're very cumbersome, time consuming and expensive. What Labour's proposing to do, which in theory must be a good idea, is to get that pay parity and pay equality for people of the same and different ethnic minorities or disabled. So in principle, absolutely fine, makes complete sense morally. But given how difficult the legislation is under the 1970 Act, as was, there are genuine concerns it's going to take quite some effort by the government's legal department to produce legislation which is going to be have the impact it's designed to have. Whether or not they will sort of take the opportunity to look at the whole structure of equal pay law to simplify it is quite possible. And certainly there's many employment lawyers and other commentators who would say that this is the ripe opportunity to do that, because the legislation that we've had in place for so many years around equal pay is just so difficult and so unuser friendly, and doesn't really achieve the intended parity that it's trying to create.
Yeah. Sorry, Stephen, you go.
Sorry, I think there is a real problem with the proposals, which is pretty clear if you think about it. Equal pay is a group of women, or indeed group of men, comparing themselves with members of the opposite sex, which is fairly straightforward to pin down. The issue of who an ethnic minority is and to whom they are comparing themselves in the workplace is much more complicated, much more difficult to pin down when comparing people, groups of people usually. And I think that the same goes for disabled people as well. Finding a group of people who, I know it's an individual, right, but finding a group of people who can compare themselves with another group of people doing a similar job is going to be much more difficult than it is, I think, as Greg says, the regime we've had for the last 54 years, and what was already quite complicated is going to become much more complicated still if these plans are put in as they're suggesting.
Yeah, and I think, the proposal that larger employers report on these pay gaps could well be difficult as well if they don't have the information to provide, the statistics, because not everyone will feel comfortable or want to disclose a disability, for example, even if it is on an anonymous basis. So it'll be interesting to see how that plays out. I wanted to go back to the day one unfair dismissal rights, because I think a lot of employers will be looking at that and thinking about how that might impact them. And Greg, you mentioned that there was going to be an operation of probationary periods to assess new hires as a potential for not, for an ability to dismiss fairly. Stephen, what do you think that probationary period exemption might look like?
I can't see how one is going to operate without the other. I mean, how can you have a day one right not to be unfairly dismissed, but also have a probationary period that bites? If you're no good and I take you through a proper probation period, is that going to be a defense to a claim for unfair dismissal? or is it actually going to be a preliminary which the employer and employee have to go through before the employee can be dismissed and make a claim for unfair dismissal? It's a tricky one, I think, but I would suspect that employers will be obliged to go through a much more effective probationary process than they do at the moment. And that if they go through an effective probationary process, then either the employee won't be entitled to bring a claim of unfair dismissal within the first 6 months, let's say, or it will be a very clear-cut defence to a claim for unfair dismissal. Otherwise, there's no real point to it, because if I can claim unfair dismissal on day one, and the way I handle the probationary period is not material, or is only part of my defence, then there's no point in me having a probationary period, really, because it makes no difference to my liability as an employer. So I suspect that we'll have some form of preliminary period where you employ somebody and you can dismiss them within 6 months, provided that you take them through the statutory guidance about probation. And I think that's a good thing, because too often people don't really implement their probationary periods properly. They wait for 18 months because they're getting up to the 2-year period, and all of a sudden they decide that someone who's now quite well settled in their employment isn't very good after all. And I think that's disruptive for both employer and employee. So I think that's I can't see this day zero unemployment unfair dismissal rights surviving consultation with employer groups such as the CBI. I just don't see it happening, and it's one of the issues that I mentioned at the beginning. So if I was to guess, I would say probably about 6 months. Dismiss if you're on if you've taken them through a proper probationary period. If you don't, you just terminate them, then of course they'll sue you for unfair dismissal. The period of employment you need to make in order to make a claim of unfair dismissal reflects the political party that is in power at the time. Prior to 1999, it was 2 years. Then in 1999, it became 1 year. In 2012, it became 2 years again. And I suspect in 2024 or 2025, it'll be 1 year again, or perhaps 6 months. Why do these keep changing? Because the government changes. That's the reason. And I don't think it has anything to do with making us more competitive or less competitive. It's simply a political stick. And of course, you don't have to pass primary legislation in order to change the continuity of employment you require to make a claim for unfair dismissal.
Interesting. So what are the timings for all of these bills then, Greg? When should we expect to see them?
Not for a while. There's been, the way it's been publicised is that within the first 100 days, the government will introduce legislation to do these things. Well, that's not exactly accurate. The 100 days runs out on the 12th of October. Where will we be by then? The furthest we will be is we may have draft regulations or legislation for the two elements, the employment rights element and the equality and equal pay element of legislation. Even if we have that draft legislation, there always has to be a proper consultation period with the unions and business representatives over that legislation. So we're a long way off having any of this legislation coming into force, it seems to me. Sometime in 2025, possibly for the Employment Rights Bill, because that may be seen as an easier one to draft and to get onto the statute books. The Equality Bill may be more time consuming just because of the complexity of the legislation. If they do mirror the equal pay type legislation that we currently have in place, it's going to take some drafting and consultation before we get that brought into force. There's one or two things which may be within the 100 days. For example, the Labour government has said that they will remove the age brackets for the national living wage. So different national living wage levels for different ages they will remove those. It may be that they do that sooner rather than later, because that is relatively straightforward from a legislative perspective. But yes, there will be noise within 100 days. There will not be any significant action until well into next year, possibly into 2026.
Okay. All right. And so we've had a couple of bits of legislation mentioned in the King's Speech, but I think a lot that was trailed but not mentioned in the King's Speech. What things were promised but not mentioned, Stephen, that we might expect to see?
Well, I think the most important was that Labour hoped to clarify the age-old question of who is an employee, who is a worker, and who is a contractor. And they've certainly shelved that for the time being. I think probably for good reason, because as soon as you define precisely who a worker is, then you can precisely define who a worker isn't. And unscrupulous employers might define people as not being their employees if they have a government definition of who is an employee. The alternative is that they may simply merge worker and employee status together. But again, that leaves the problem of who is a merged employee worker and who is a contractor. I suspect they'll just leave that to the courts to continue to consider on a case-by-case basis. I don't know whether Greg agrees with me on that. There's a couple of gimmicky things. There are the right to switch off, as workers have in France, Ireland, and Belgium at the moment. I'm harassed by my employer. I have the right to not to receive emails from them or not to respond to them within certain fixed periods of time. I think that would be quite hard to pin down. I'm not sure it has made an enormous difference to Irish, French, and Belgian workers. Harassment looked like it was going to be tightened up, but in fact has not been. And most surprising, I think, increasing invitation periods for issuing employment tribunal claims from 3 to 6 months. I'm greatly in favour of that. I think 3 months is a ridiculously short period of time, and but they've not done that either. And I may be mistaken about this, but I think you can do that by ordering council or statutory instrument as well. You don't require a bill to do it, which may be why it isn't in the King's Speech, because the King's Speech relates to primary legislation only. So that may be the reason why it's not mentioned, and it's coming up quietly into Parliament over the next few months.
Interesting. So we've got a few things that are bubbling away from the King's Speech that aren't going to be imminent, but will need some planning, I think it's fair to say, and things that may come downstream in the future. So if I could get one takeaway from each of you for our listeners as to what to watch out for, perhaps some planning tips, what would that be? And I will come to you, Greg, first.
Okay, all right, I'll get mine in first then. No, I think thing to start thinking about is around probationary periods, because over the recent years, since we've had the 2-year rule, I think employers have either removed them entirely from their employment contracts, or they kept them in but haven't really policed them probation periods as they might have done in the past. If we get to a situation where it's a day one right to claim unfair dismissal, everything will come down to that probationary period. So if you are reviewing your contracts, check what it says about probationary periods. If it says nothing, then you've got to think very carefully about bringing something in, or perhaps waiting until we know more about the legislation. But it seems almost certain that we will be in a situation where that probationary period will become critical. And so make sure that you consider that as you review your contracts the next time you look at them.
Yeah, important stuff. Stephen, what's your top tip?
Oh, I agree with Greg. Probationary periods have been under-policed. They're now going to be vital, but we don't know why they are. we're going to have to plan with known unknowns about probationary periods, and we need to go very swiftly up to speed when we get them. I suspect there's the questions of unions, their ability to come into the workplace and recruit is going to pose issues for employers who are not used to dealing with unions. And I think overall it's going to be easier for unions to call strikes and to be recognised than it has been for many years. And I think that's an important point, which is slightly under the headlines, I think, of the government's legislation. And that, I think, is bound to take place because the Labour government is supported by the unions. And so I think that's very important and will make a big difference.
Well, it seems like there'll be some interesting times ahead, and I've got no doubt we will be revisiting this subject and all of this legislation once it comes in and once we have a little bit more clarity on what the detail is and what the impact is or will be on organisations. So thank you both for your insights today, and thank you very much for listening to this podcast.